Okay, Samantha, can we start our record?
Yes,
And
Judge.
I doubt I would have this many people on YouTube if we had good news, so I'm assuming we're going forward. So let me just say that this is, and I hope I'm saying this correctly, Therix Edward Johnson versus Dr. Frida McCarter and others. This is 2020 CV 332330. And today is, January the 15th, 2021. I think we have this on the calendar for a motion for the defendant's motion for protective order. And I would just like to say for the record that everyone is appearing via the Zoom teleconference platform. The court has activated the YouTube live stream feature that our court provides to make sure that we comply with our very sacred obligation that we take very seriously to continue to make the public's business open and accessible to it. And let's go ahead and, if we may, do some introductions. And I'll start with defense counsel.
Yes, Your Honor. My name is Kristen Pearson.
Sorry, Ms. Pearson, I did that. I'm so accustomed to criminal cases. Let's start with
the plaintiff. Very well.
Thank you. Good morning, Your Honor. I'm Alan Bodiford on behalf of the plaintiff, Mr. Johnson.
Okay, good to see you. Good morning. Now, I'm sorry, defense counsel.
Oh, it's no problem. Kristen Pearson and Ms. Angie Doan on behalf of Piedmont Henry Hospital, Mr. Johnny Gaines and Mr. Russell Wells.
Okay.
Your Honor, Paul Reynolds on behalf of Dr. McCarter and her practice, Atlanta Surgery Associates, LLC.
All right. Now, that's probably a good way for me to begin. The motion, well, I guess let me put it in the form of a question. Does the defendant's motion for protective order apply to all defendants?
Yes, Your Honor, it does.
Okay. And Mr. Bodiford, I am going to, I think I'm correct in saying that we're on this morning for the protective order regarding Dr. Howden. So I'm going to let the defendant's counsel begin. Whoever'd like to start.
Yes, Your Honor. I'm going to lead us off to make things concise and streamlined, and certainly we'll have Mr. Reynolds correct whatever I'm deficient in after I'm done. But Your Honor may remember that we discussed this particular issue on September 29th via a teleconference. And so the resulting motions practice has ensued. To reorient the court very briefly on the factual predicate, this lawsuit was filed in January of last year, so 1 year ago. And within the first 6 or 8 weeks of the filing of the complaint, defense counsel retained Dr. Colin Howden, who is a gastroenterologist in Tennessee, as a retained litigation expert to review the case on causation and damages, not on liability about the retention of the surgical sponge or standard of care. Dr. Howden has returned favorable reviews for us, and so we continued to engage him throughout the first half of 2020. In the plaintiff's discovery responses and in the plaintiff's deposition, which occurred in April and June of last year, the plaintiff never disclosed Dr. Howden as some physician that he treated him or had a special relationship with him. And I say that, Your Honor, not to be in any way critical of Mr. Johnson or Mr. Bodiford. It's only meant to prove the point that this is not a physician that Mr. Johnson, the plaintiff, has any recollection of. Mr. Bodiford has been kind enough to share that with us. He doesn't know his name. He doesn't remember him. He doesn't have any recollection of Dr. Howden. As we went on in the case, in July of last year, we received for the first time medical records from a hospital referred to as The Med in Tennessee. We knew that Mr. Johnson had been treated there. We just didn't have those records for ourselves to review. And upon reviewing those records, we saw Dr. Howden's name in the records, to our surprise, as one of, I think, 3 physicians who participated in a May 2015 colonoscopy on Mr. Johnson. And so what we did, Your Honor, in the interest of being open and honest with Mr. Bodiford, is I called Mr. Bodiford up and I let him know that, an expert that we had retained in the case, we just learned had been one of several physicians who participated in one procedure on Mr. Johnson 5 years ago. And the point of the conversation was to ask for HIPAA permission so that defense counsel could talk to Dr. Howden about that colonoscopy. And Mr. Bodiford kindly declined that, but also, which is what has brought us here today, launched a much broader overall objection to Dr. Howden continuing to serve as a retained defense expert in the case. And so we spent several months, all defense counsel and Mr. Bodiford, trying to collaborate informally to try to work through it. And we weren't able to get anywhere. And so that's what led us to the September teleconference with the judge. After that teleconference, we continued to work with Mr. Bodiford, who's been nothing but kind to all of us. And I have to say, Judge Barwick, we all have enjoyed a very, very nice relationship in this case, despite that we may have these disagreements about the law. We've all worked very well together, and I certainly appreciate Mr. Bodiford being gentlemanly and open to talk to us about these things, which he has. We continued to collaborate in the fall after the teleconference with Your Honor to try to resolve the issue. We sent more case law. We asked Mr. Bodiford if he had any case law to support his position. He did not. And so it necessitated the motion that we filed just a few months ago. And I will say, Your Honor, up until Mr. Bodiford's kind response brief, we were a little bit confused as to what the nature of his objection really was. Originally, Your Honor may recall that the nature of his concern was relevance. So he just wasn't able to appreciate how Dr. Howden, as a gastroenterologist, could have anything to say about the procedure for a surgical count standard of care. And we've tried to emphasize to Mr. Bodiford that Dr. Howden is not a liability or a standard of care expert. He has and will have absolutely no opinions whatsoever about the care that is alleged to have been negligent. He is only a damages causation witness. What are Mr. Johnson's damages he's alleged as a result of this retained surgical sponge? And what's the context of that, considering his prior medical history and his subsequent medical history? That's it. We now appreciate from Mr. Bodiford's response brief, which we're very appreciative of, that he has 2 concerns. The first is that Dr. Howden ought to be excluded as an expert as a sanction for a perceived HIPAA violation. And we want to emphasize to Your Honor that there has actually been no HIPAA violation whatsoever. We have purposefully never sent Dr. Howden the May 2015 colonoscopy records. We have never spoken to him about it. And so as a matter of fact, there has been no violation of HIPAA. And so there ought not be any kind of sanction for conduct that has not occurred. And so I think we can easily take that off the table. The second argument that Mr. Bodiford makes is one of relevance, public policy and prejudice. And so in his response brief, Mr. Bodiford cited to 2 cases, one, the Pillar case from New Jersey, the other, the Hampton case from Montana. And his point is, of those cases, that it just is inequitable. It just feels wrong. It just doesn't look right for a treating physician to be a defense witness. And Mr. Bodiford understandably expresses a concern that if the jury knows Dr. Howden is a treating physician of Mr. Johnson's one time back in 2015, that they may attach greater significance to his opinions in the case, and therefore Mr. Bodiford and his client would be prejudiced. So with respect to the first argument, Your Honor, with the HIPAA violation, let me see if Mr. Reynolds and I can make this a little bit easier for Mr. Bodiford, more palatable to him and to the court. We've originally asked Your Honor as part of the order to allow us to speak with him about that colonoscopy. If it makes things better, Mr. Reynolds and I are more than happy to not provide Dr. Howden with those 2015 colonoscopy records, not to speak to him until the time of his deposition. And that way there will be no private conversations about that colonoscopy that will occur outside of Mr. Bodiford's presence, and that can assuage any potential concern of HIPAA. We're happy to do that if that helps things.
Wait,
And we're
let me just understand exactly what you're saying there, Ms.
Yes,
Pearson,
ma'am.
and I'm sure you'll clarify it as you go on, but you're asking that defendants be allowed to speak to Dr. Howden regarding the colonoscopy, but not see the actual records until his deposition is taken?
No, Your Honor. So originally, there's two reliefs that we are asking for.
I'm sorry to interrupt again, because
That's okay.
I think I heard you say earlier that you have not yet shown Dr. Howden the records from the
That is correct.
2015 colonoscopy.
That is correct.
Okay.
Nor have we spoken to him about the 2015 colonoscopy. So to date, there is absolutely no basis for a HIPAA violation, and therefore no basis for a sanction of a HIPAA violation in excluding Dr. Howden.
Okay.
What I was transitioning to, Your Honor, and I apologize if it was inartful, was moving forward. That if it continues to be a concern and if it will help things, then Mr. Reynolds and I will not ever give Dr. Howden those records and speak to him about that 2015 care until the time of his deposition, when Mr. Bodiford is present and has equal opportunity to hear of his thoughts about care that he was involved in with Mr. Johnson. We're happy to do that. We don't mind making that concession if that helps that particular issue about the colonoscopy records. But a secondary issue, and the bigger issue, Your Honor, is the plaintiff's objection to Dr. Howden continuing to be a defense expert altogether. Does that make sense? So that's the biggest issue that we have, the subset of which would be the discussion of the 2015 care. So with respect to the biggest issue, which is Mr. Bodiford just wants to prohibit Dr. Howden from serving as a defense expert altogether, I'm afraid it just doesn't have any legal support. So we've cited to Your Honor in both of our briefs, the original motion and the reply, a total of 8 Georgia cases that demonstrate a 40-year history of Georgia courts believing that treating physicians of plaintiffs can serve as expert witnesses, and they can do so for either side. There have been cases that we've cited that permit a plaintiff to do it, and there are also multiple cases we cited, Your Honor, to that specifically allow a defendant to rely upon a treater like Dr. Howden for their case. And Georgia's public policy allows that and takes no issue with that. And so there is no Georgia case that can be cited, and Mr. Bodiford acknowledged this in his response brief. They can't find a case where a Georgia court has precluded a treating physician from being an expert for the defense or for the plaintiff. Notably, Your Honor, the only restraint that Georgia courts over 40 years have placed on this right is that of disclosure. And so if the defendants were only relying upon Dr. Howden for the care he was involved in and nothing more, so just the May 2015 colonoscopy, then we could do that and we just would never have to tell Mr. Bodiford about it in advance. We wouldn't even have to disclose him as an expert. We could bring him to trial and there would not be an objection because he's a treating physician being called to talk about his care. But because we have and want to use Dr. Howden for all of Mr. Johnson's records, so not just the 2015 care, we acknowledge we have an obligation to disclose him to Mr. Bodiford. And we've done that at least 5 times now. And Mr. Bodiford has a right to go take his deposition, which I assume he will. So the only caveat to the very broad Georgia rule that allows treating physicians to be experts is disclosure. And we've met that here and we take no issue with that obligation. As
Can I
yes,
just
ma'am.
ask you, Ms. Pearson, and again, I'm sure you're going to get to this, and I hate to
That's okay.
hijack your argument. I've read your brief. I have not read each and every one of these cases. I will be candid with the court about that, but I have read the synopsis. So let me just ask you directly, is there any authority that says in order for a treating physician to be an expert, there has to be a HIPAA waiver?
No, ma'am. In fact, the state of Georgia law says the exact opposite, that once a plaintiff puts his or her medical condition in issue in a litigation like this, there is an automatic waiver of the HIPAA rights. Now that waiver, Your Honor, Mr. Reynolds and I would never tell Your Honor, is totally unfettered and unlimited. Mr. Johnson still retains rights. I mean, all of his privacy is not thrown to the wayside because he has filed this lawsuit. But the answer to Your Honor's direct question is no. There is no Georgia case that says a treating physician would be violating a patient's HIPAA rights if they were to offer testimony in a legal case as an expert. In fact, the Georgia cases that I cited, Your Honor, say the exact opposite of that.
Okay, thank you.
Sure. And so as I was alluding to earlier, Your Honor, and we cited, Your Honor, to 8 Georgia cases that have dealt with this issue since 1982. And we also supported that with cases from other jurisdictions that have held just the exact same way that Georgia has had. And one seminal case is the Torres case out of California from 1990 that we've put in both of our briefs. And that is an exact replica of this case where the defense went out and retained a physician to be an expert, later finding out that he had been a treating physician of the plaintiff patient. And the courts allowed him to continue as a defense expert. And that would be a particularly helpful case, I think, for Your Honor to read because it gives the exact reasoning that we're articulating today. And so, Mr.
Again,
Yes,
I'm sorry.
Sure.
Are there any of the Georgia cases, and I will also add the Torres case, that in which the treating physician who becomes an expert was part either a defendant or, well, I guess a defendant. In other words, is there any case that says, look, he can testify and he can even,
Whatever, right.
physician can testify, treating physician can testify, treating physician can, has a sort of umbrella waiver because treating physician is subject to some liability. Do these cases require that the treating physician expert is defending him or herself?
I'm following you now, Your Honor. The answer is no. In all of the 8 Georgia cases and in all of the other jurisdictions cases that we cited, Your Honor, the treating physician, the Dr. Howden in those cases, has zero connection to the underlying litigation. They're not defendants.
Okay.
They have no litigation role in the case. They are outside non-parties who have simply been involved in the patient's care and treatment in some form or fashion. Does that answer your question?
It does answer my question. Thank you.
Sure. And so Mr. Boterford's, as I alluded to earlier, his argument now is it really is against public policy and it would be highly prejudicial. So if I may, Your Honor, let me address that. First and most notably, the state of Georgia does not subscribe to that public policy. And we know that because we have a 40-year litigation history, starting with the Orr case, the seminal Orr case in 1982, that has been cited by multiple other states for 40 years, that Georgia itself does not believe in the quote, public policy argument of annihilating non-party treating physicians from giving testimony in cases for either side, the plaintiff or the defendant. So that public policy does not exist in Georgia. Number two, the cases that Mr. Bodiford cited from New Jersey and Montana have a distinguishing factual feature that we don't have here. In those cases, the treating physician was referred the patient by the defendants in the case. So that would be equivalent to any of the defendants sued in this case having referred Mr. Johnson to Dr. Howden for care, and now we're wanting to use Dr. Howden as an expert. But that didn't happen here. Dr. Howden treated Mr. Johnson 5 years before this and 3 years before the surgery that is at issue. So there is no referral relationship that was seminal in those cases cited by Mr. Bodiford that we're dealing with here. Dr. Howden has zero connection with any of the defendants, never talked to anybody about the care of Mr. Johnson in real time, right? Number two, those cases cited by Mr. Bodiford, the Pillar case and the Hampton case, specifically allowed, in fact, the treating physician to give opinions on causation and damages. The issue in those cases was whether that treater could give testimony that went to liability, standard of care. Well, that's exactly how we're using Dr. Howden here, is causation and damages only. And so even Mr. Bodiford's cited cases, the end conclusion in them supports the defense position. Those treating physicians were allowed to testify on damages and causation in those cases, no different than Dr. Howden here. And so those cases, Your Honor, are not only factually distinguishable, but the conclusion of them cited by the plaintiff actually supports the defense position. And Mr. Bodiford is unable to cite us or this court to any Georgia case that has excluded a treating physician like Dr. Howden from giving testimony in a case either for the plaintiff or the defendant. And the reason Mr. Bodiford has not been able to cite it to us is not because of any deficiency on his part. It's because the case doesn't exist. There is no case in Georgia that has ever done this that he's asking us for. So if I may, Your Honor, Mr. Reynolds and I are happy to, in the spirit of trying to collaborate, we have come up with an idea to help Mr. Bodiford's, quote, prejudice concern, the concern that if a jury knows Dr. Howden on one day back in 2015 treated Mr. Johnson, they may attach greater significance to his testimony. We are more than happy to never submit evidence to the jury, never introduce testimony or evidence to suggest that Dr. Howden was involved in Mr. Johnson's 2015 colonoscopy. We will not do it. We will instruct Dr. Howden not to do it. And so that then takes away the jury ever knowing that Dr. Howden treated Mr. Johnson back in 2015 and eliminates Mr. Bodiford's prejudice concern here.
So let me ask a question that's gonna, you're gonna be depressed and think we're going all the way back to the beginning, but
Okay.
is he a testifying expert?
Yes, ma'am.
Okay. I'll write that down this time.
No, that's okay. He has not yet testified because we're not there in the case yet. So he's been disclosed. This is, again, no fault of Mr. Bodiford's. He hasn't yet asked for his deposition, but he certainly can, and I assume he will, and he's entitled to get his deposition, and we're entitled to give it to him. We just haven't gotten to that phase of the case yet, but absolutely he would be open for a deposition if Mr. Bodiford wants to depose him, and we would be calling him to trial. Yes, ma'am.
Okay, so the idea there is that you're preempting the argument that the jury is going to sit there and say, well, this guy's been in his inside, so he should know.
Yes, Your Honor.
Okay.
I mean, we certainly don't agree that alleged prejudice is sufficient to exclude Dr. Howden, but we're trying to be collaborative, Your Honor, and we're trying to assuage any of Mr. Bodiford's concerns, and that's an easy fix. We just won't ever tell the jury that he was a part of the 2015 colonoscopy, and nor will Mr. Bodiford.
You don't have to answer this question, and this may be truly unfair, but are you trying to hold on to him so hard because you spent a lot of money on him? Or
I don't mind.
Does he have unique knowledge that no other expert might have?
I don't mind answering that question at all, Your Honor. There are several reasons why we appreciate Dr. Howden's continued role in the case. Number one, we certainly have engaged with him long before we ever found out that he had some role in this 2015 colonoscopy. And so certainly, Your Honor, we have spent time and resources on him. Number two, however, beyond that, because that's less important, is the kind of person that he is. He is an exceptionally well-credentialed gastroenterologist with particular expertise in a lot of the medical issues that are involved in this case, underlying issues for Mr. Johnson. And he is a very nationally renowned expert. And so in our effort, Mr. Reynolds and I, our obligation to our client is to try to find the best well-credentialed expert on the particular medical issues in this case to best represent our clients. And that for us, given the contours of this case, is Dr. Howden. I don't disagree with you, Your Honor. Is he the only gastroenterologist in the universe? Well, of course not. Is he particularly suited to the medical issues in this case? Absolutely. Does he have a great amount of clout and presence? Absolutely. Do we believe that the best way we can adequately represent our clients is to present to the jury the most highly qualified expert on these particular medical issues? Absolutely. Would our clients be handcuffed by having to pick a lesser qualified expert? Absolutely. And so I hope that those features answer Your Honor's questions.
Have you used him before?
Never.
Okay.
Never used him before because we have never had the specific medical issues that are involved in this case. And I'm happy to share with Your Honor that I specifically researched who is expert in these particular set of underlying gastrointestinal issues that we have to deal with. And his name's everywhere. And so he is uniquely suited for this particular case because of his subspecialization and his focus and his years of research and the kind of expert that he is. Yes, ma'am.
Okay.
And so the only other thing I would raise to Your Honor's attention is something that is in the last page of our reply brief, which is, and I certainly hope this does not come across to Your Honor or to Mr. Boterford as a threat, because it's not meant this way, but I do want to explain another nuance of the law. Even if Your Honor, we hope you don't, but even if Your Honor were to say, okay, he's out, he can't be a retained litigation expert in the case, then unfortunately, it does not prevent him from getting involved in the case, just an entirely different way. So it's like the Wizard of Oz, a horse of a different color, right? So because he's a treating physician, none of us can ever erase that. We cannot evaporate his role in Mr. Johnson's care. And under the 40 years of Georgia law that we've cited, we as the defense, even if we don't go out and retain him as a testifying litigation expert, because he's a treater, we have the absolute legal ability to go depose him ourselves and say, Dr. Howden, we're going to go take your deposition because you're a treating physician. You treated Mr. Johnson in 2015 one time in one colonoscopy. And under Georgia law, we have the ability to give him the hundreds and thousands of other medical records on Mr. Johnson as we wish and ask him opinions about that. And there's no law that prevents that. And Dr. Howden, effectively, Your Honor, he can't be silenced. And so even if he's excluded as a retained litigation expert, his testimony still comes into this case as a treater and just as a treater. And so I raise that again, not in any kind of a threatening way, but to explain that the objection here to Dr. Howden as an expert is a moot argument and one that is a functional dead end, because he still gets to testify in this case. He just will be called something different. And to me, Your Honor, that
isn't that where Mr. Boterford's relevance comes in, though? We do still have the evidence code.
Oh, sure, but he would be highly relevant as a treating physician because he has done a colonoscopy on Mr. Johnson and could testify as to what those findings are and the significance of those. He can't be excluded under the evidence code. He's a treating physician. There is no law that excludes him from testifying as a treating physician. It can't be done. And frankly, Your Honor, from an argument standpoint, that way would be way worse for Mr. Bodiford, because under that pathway, then Dr. Howden is announced as a treating physician, and the jury knows he's a treating physician, which is exactly what Mr. Bodiford's concern is. So actually that pathway is worse for the plaintiff than this pathway, which is allowing us to continue to do as we have done all of last year. Use him as a defense expert. Mr. Bodiford gets to depose him. We are happy to never tell the jury that he was involved in that colonoscopy. We're happy to do that. And then the jury never knows that he was involved. But the other way, the jury's automatically going to be told he's a treating physician, which would seem to work against what Mr. Bodiford's concern is. And so those are just my final sort of parting words that I just think somewhat moot this argument, because he gets to get in one way or the other is my point. And so I thank you, Your Honor, for your time. I'll let Mr. Reynolds, if it's okay with you, fill in where I was deficient and make some points that he may want to make to Your Honor.
Mr. Reynolds?
Your Honor, I've known Ms. Pearson a long time, and unsurprisingly, she did not miss any points. I do want to disclose to the court, just to respond to one question you asked her, and so that there's no allegation ever that I've tried to hide anything. I have consulted with Dr. Howden in a different case since this one. I had never consulted with him prior to this. I don't believe I've identified him. I don't know if he will testify in the other matter, but I just want the court to fully be aware of that. And I'm not trying to hide that from anyone. I agree completely with Ms. Pearson. There has been no violation of anything. I'm happy to answer any questions about that with regard to if there's been a HIPAA violation. I will state for the record to confirm we have not had any conversations with Dr. Howden regarding the colonoscopy and his treatment of the patient in 2015. Other than that, I completely agree with Ms. Pearson and everything she said.
Okay. Well, I'll tip my hand a little bit there, and which is not a big secret, because I'll ask Mr. Bodiford the same thing, which is, of course, it's in Dr. Howden's interest that he not, you're severely limiting a person's ability to make an income if you say nobody who's been involved in a colonoscopy can ever be a testifying expert. And that's one thing I want to ask Mr. Bodiford as well. So my question was, it's certainly in Dr. Howden's interest that he not be disqualified in a Georgia court on this basis. And that's why I wanted to know, have you used him before, and is he the guy out there? Okay.
I don't know if there's a question, Your Honor. Again, that's what I just wanted to disclose. I wanted to be as upfront and honest about it as I possibly can. So
okay. And y'all are telling me too much. Next, you're going to be giving me your SAT scores. Candor, and I don't want any more candor.
That's okay. Well, and I don't mean to interrupt Mr. Bodiford's opportunity, but I can also address Your Honor's last question. I care less about Dr. Howden's income than I care more about his right to serve as a witness in this case, whether it be the purple horse as the retained litigation expert or the yellow horse as a treating physician. But what I can do, Your Honor, to help that is point you to the Christensen versus Munson case from Washington that is on page 8 of our reply brief. And that court went to great detail to say, you cannot silence a witness. One party cannot restrict another party's access to a witness. And Dr. Howden is a witness in this case. And the fact that he's being called upon by the defense is of zero consequence. And the fact that the defense wants to use him as an expert doesn't matter. And the fact that the defense is planning on using him as their litigation expert doesn't matter. The plaintiff cannot thwart the jury's ability to receive evidence from a witness. And I don't think Mr. Bodiford is ever trying to do that out of some poor motive. I don't attribute that to him at all. But at the end of the day, it just can't be done. And it couldn't be done in Washington, and it's never been able to be done in Georgia.
Okay. Okay, great. Thank you very much. What did you have something, Mr. Reynolds?
No, Your Honor.
Okay, come on, Mr. Botiford.
Yes, Your Honor. Thank you.
Thank you.
Being here today for us.
Judge, excuse me, could you
Yes.
just give me 1 minute, please?
Can we take one second, everybody? Go ahead.
Okay, I'm ready.
All right, Mr. Botiford.
Yes, Your Honor. Thank you for hearing this motion today and for your time. But they are so correct, and they went basically through my reply brief that I submitted here word for word. You know, Ms. Pearson's always trying to steal the show. So I must admit, she has pretty well hit all the high points that was in my reply brief. And I have not been able to find a case on point directly in Georgia on this issue. So I tried to look at other states in reference to it. On the HIPAA violation, Judge, let me just tell you, and it's even in my brief, that my reply brief here, where I put that, hey, if she did violate HIPAA, it was unintentionally, because I must admit, I didn't know who Dr. Howden was. Mr. Johnson sure don't know who Dr. Howden was. He's being treated at a place called the Med in Tennessee. And you know how it is when you go to a hospital. God only knows until the bills start coming in of who treated you or whatever. That is what has happened here. So I even explained that in my response here to this, okay? I do contend that the Baker versus Wellstar Health Center case that's in my reply brief here, a 2010 case, that right to medical privacy as to the condition at issue in the case, okay? Judge, we're getting down to where I have problems, and I set this out in my response in reference to the dangers associated with ex parte interviews of healthcare providers. One, the potential for unwarranted probing into matters irrelevant to the litigation, yet highly sensitive and possibly prejudicial to the plaintiff patient. And Judge, the reason I'm saying this case hinges upon a lap pad sponge that was left in Mr. Johnson, okay? Dr. Howden didn't treat him for that in 2015. So, I mean, he's going to be discussing other issues there. I'm afraid that the defense counsel and Dr. Howden. Two, the potential for disclosure of information such as mental impressions not documented in the medical records that the healthcare provider has never actually communicated to the patient plaintiff. And three, the potential for defense counsel to influence the healthcare provider's testimony unwittingly or otherwise by encouraging solidarity with or arousing sympathy for the defendant healthcare provider. Judge, I'm glad you asked this question. I didn't know if they had used Dr. Howden in the past. They've been honest. I'm not going to discredit that. They probably have never used Dr. Howden because they've never disclosed to me. And I think everybody has been very transparent in this case as far as giving information. So the bottom line here is I believe that if Dr. Howden is being used as a witness, he comes in, he testifies, he could testify as to anything he wanted to, unknown at this time as far as what he would testify to, but as the defense potential witness, he's going to, for causation or whatever, where's he coming from in reference to their causation when he had no involvement with any of the issues that are involved in this case? I believe where they're going to come from is, oh, well, Mr. Johnson still has the gastro problems today that he had in 2015. That is not the major issue here. The major issue is the liability and the amount of compensation for leaving the lap pad in the in Mr. Johnson on the first surgery, unless they're trying to use Dr. Howden then to testify, well, based upon the second surgery that Dr. McCarter had to go back in and remove and do additional surgery that we contend is based upon leaving the lap pad in, then I believe that that is where they must be coming from as far as causation goes here. This case, as I stated earlier, and my brief points it out, we do not have a ruling squarely in the state of Georgia in reference to the issue on all fours here in reference to this issue. But I would point to the court that whenever we're not directly, we can use Rule 403. I pointed out to the court in my response to this. And Judge, I'm not going to really waste your time in reference to trying to make any other arguments, because I just believe that Dr. Howden should be excluded from any report or whatever in this case. And from the case law that I read, they can take his deposition as the treating physician, but I respectfully disagree that I'm not for sure they can provide all of the other records to Dr. Howden in reference to just his treatment. I believe that Dr. Howden could be used, his testimony could be taken that he read a colonoscopy and this was his understanding. And then their other expert that they would have retained can take that information and incorporate that into the defense of the defendants in this case, Judge. So I pointed out my cases in here. They take exception to them. I think that it's good law because of the way other states has ruled in this situation. If not, Judge, you're going to have doctors talking to experts, the treating physicians talking to experts, and then that is disclosing information and violating HIPAA in reference to the information that's being presented to the defense experts or to the defendant's attorneys. So I would ask that you exclude Dr. Howden in this situation because he has been a treating doctor. And I believe it's relevant what happened. I mean, for his testimony to come in here, the relevancy is still present, in my opinion. Thank you.
And Mr. Botiford, I don't disagree on the relevancy. I mean, but let me ask you this. Let me ask you to address whether you think there is, the defense have posited that there is an automatic HIPAA waiver when a plaintiff, and I know Ms. Pearson's going to want to tighten that up, but that there's an automatic HIPAA waiver when a plaintiff sues for medical malpractice. Do you believe that is true or not true? And if not true, why?
I don't believe that that's true, that you got a blanket policy just because you file a medical malpractice case that there's a total HIPAA waiver, because if so, and let me make sure I get this right, because this HIPAA, I can always get it mixed up if you're not real careful with it, okay? Just because you sue does not mean that everybody else that has treated you in the past is free to release your medical records without a court order and somebody showing the relevancy of those documents.
Okay, well, again, you want to bring relevancy into it, and I'm not ever going to take relevancy out of it because Title 24 doesn't let me take relevancy out of it. So, I mean, just putting that over on the shelf. So what you're saying is if I sue for medical malpractice, claiming a sponge was left during surgery, I'm not allowing somebody to go find out from my, I get heart surgeon from 10 years ago, what those records were. Okay.
That is correct, Judge, because now they're going back. It's not related to what happened here, what damages he had in reference to the sponge being left in Mr. Johnson. What happened in 2015 was different surgery, or even if it was related, he had some gastro problem at that time. it's still not related to the damages for a foreign object left within Mr. Johnson.
Is that a different question though, Mr. Bodiford? I mean, that's what I've struggled with since our phone call is, again, I'm not saying that evidence doesn't have to be relevant to be admitted. Of course it is. And there's lots and lots of things that juries don't get to hear about that they wish they could hear about.
Correct.
And they'll tell you afterwards, well, why didn't you tell us that? Well, the judge didn't let us. I'm never going to throw Title 24 out. I'm just trying to understand how that relates to discovery. Okay, I got it. I may come back to you, Mr. Bodiford. Ms. Pearson, would you like to respond?
Yes, Your Honor. Thank you for the chance. So the first thing I heard again is relevance, and that's very confusing to me and Mr. Reynolds because with all due respect, Mr. Bodiford does not get to be the one to decide how the defense chooses to defend the claims that he's brought. I mean, we don't have to ask his permission to bring a certain kind of expert, and we don't need him to agree that the expert testimony is relevant. And so we have an obligation to our clients to defend this case on standard of care, on causation, and on damages. And the fact that Mr. Bodiford may not today, as he sits here today, understand and appreciate how Dr. Howden's testimony fits in this case is by no means a basis to exclude him. The Civil Practice Act gives Mr. Bodiford the opportunity to go take his deposition. And to be candid, Your Honor, without being disrespectful, it doesn't matter what Mr. Bodiford thinks. I mean, he doesn't have to like Dr. Howden's testimony. In fact, he probably won't because it's not going to help his case, but that's not a legal predicate to exclude a witness. So if Mr. Bodiford doesn't like our standard of care experts, he's going to ask Your Honor to strike them because he doesn't like it, because it's not relevant to him. I mean, I feel like now we're getting a little bit, pardon me, far afield, and these are becoming emotional arguments, not rooted in the law.
Let me ask you this, Ms. Pearson, and I apologize again for interrupting. Has Mr. Johnson waived his HIPAA rights as far as Dr. Howden is concerned in this case?
Absolutely.
Okay.
And I can prove
now,
it to you.
Let me make everybody mad. I am inclined to grant the motion for protective order and let Dr. Howden continue. And I do so for the following reasons. Number one, I think we are maybe the not elephant, maybe smallish animal in the room is this, Mr. Bodiford, and I say this maybe unfairly, thinking that you and I are close enough in when we started practicing and how we've been practicing. So I apologize if I'm painting you with the broad brush of my past experience. But I think one thing we're overlooking here when we start talking about public policy is the reality of modern medicine. And for that matter, the reality of modern law practice. I mean, we're talking about mega institutions where exactly this type of example could happen, where someone could pick up a report and read it, or someone could, and I don't want to be too personal, but I was surprised when I got my colonoscopy report as to who was in the room that I had never seen. And I pay attention, but I mean, I think that we are ignoring not ignoring, but not taking into consideration reality of modern medicine that lots of people, I mean, this could have been somebody in Canada reading or maybe not, but somebody across the country reading a report who's just that particular expert. And you want that. We want to encourage, the best care possible. With the best people. And I do think that there is an argument here that if you were to exclude someone who either reads thousands of, pictures daily from having another form of practice, would to this judge be unfair. So I am going to grant the motion for protective order, but I want to be a little bit more specific about it, because in the initial protective order, not the response, but in the initial protective order, the last ask was, Ms. Pearson, it was worded funny after all the good stuff.
Is it, if you're looking at the order, Your Honor, is it that defendants, their counsel, and Dr. Howden may communicate about plaintiff's May 7, 2015 colonoscopy?
Seek as part of its order this court's permission to discuss, I wasn't looking at your order, but
Oh, okay.
your brief, plaintiff's May 7 colonoscopy with Dr. Howden. I liked what you said earlier during the argument, that you haven't shown him the records, you haven't discussed the 2015 colonoscopy with him, and that you wouldn't do so before there was the deposition. Is that?
Absolutely.
So I would like to include that language in the order.
I'm happy to do that, Your Honor. And just to be clear, at Dr. Howden's deposition.
Okay,
I'm sorry.
let me, and
Oh, I'm sorry.
here's what's going to make everybody mad. This isn't a forever ruling. I mean, I guess that something could come out, which is Rule 403-ish. I think Mr. Bodiford is correct in raising that even though I'm not willing to accept a public policy right now, something could come out that is so offensive. Dr. Howden could say something that might be truly unfair or overly prejudicial in relation to its probative value. And so I reserve the right, let me put it this way, to review this one more time before a jury hears it. And I am granting to Mr. Bodiford the right to revisit this, not revisit it in the terms of what we've talked about today, but he can certainly bring to the court's attention, wait a minute, Judge, this is the disaster I tried to warn you about, and this really wouldn't be fair. I want to preserve for Mr. Bodiford his right to do that. And finally, and Mrs. Pearson, you're gonna prepare this draft.
Yes, ma'am.
I want you guys to be thinking globally about how we get this matter concluded, because before too long, we're going to be having you on some kind of, and I'm sure there are going to be motions and so forth, but we're going to be having a status conference with you. Maybe it will be face-to-face. Maybe we just like Zoom so much, we'll continue to do Zoom even though we're all safe. And we're going to be telling you how dire our civil situation is with regard to juries. I want you to be thinking outside the box. I want you to be thinking about 6-person juries. I want you to be thinking about arbitration. I want you to be thinking about, I know you're way too early, I guess, for mediation, but I want you to be thinking about solutions now, and not a year from now when I tell you you've got another year. Okay. Mr. Bodiford, do you have anything to say?
Well, no,
Other
Judge.
than you think I'm stupid?
I think you done embarrassed me about age today, so I'm not going to say anything else, okay? And Mr. Reynolds, you don't need to be laughing. I had to watch a video the other day for my CLE, and you had to pop in. Judge, I got to agree with you, and you're being fair in reference to allowing me to come back and file a motion in limine and ask you to revisit it.
Well, listen, this girl spent 3 hours in a tunnel at Mercedes-Benz Stadium the other day, lined up for a shot because of something.
Oh, boy.
And it wasn't because I was a judge. So
Well, I hate to tell you this.
I get to bring it up.
I get to stand in line 5 minutes. I had my test and shot, at Piedmont McDonough down here and was gone.
Oh, I
That's
know the
great.
wrong people, Mr. Botifer.
Just get on Piedmont's website and you can get your shot, Judge.
You were wonderful. Well, listen, Ms. Pearson, if you can try to give some form to that and circulate it,
Yes.
any way I can help. When I read my email that I sent y'all back in September, I thought, huh?
No.
So any way I can help, let me know. And I wish all of y'all the best. And please, everybody, continue to stay safe.
Thank you, Your Honor. We'll send that. We'll work on a
Yes.
proposed order and circulate it to everybody, Ms. Cummings, today, by the end of the day.
Just relax, get it to us, okay?
Thank you, guys. Thank you,
Thank you.
Mr. Botiford.
Have a good
Thank you, everyone.
Bye.
All right, thanks, everybody.
Okay, have a
Bye.
good weekend. Bye-bye.
Thank you.
Okay, now I gotta, Jessica, gotta take us